Hi everyone, so we're just waiting for a few more people to join. Whilst we're waiting, feel free to put your name, your business name and where you're based in the chat. Thank you all for joining. I'm just going to wait one more minute and then we will make a start. All right, perfect. Okay, guys. So today we are going to make a start. And I just want to welcome everyone to today's Lunch and Learn, which is a Startup UK Lunch and Learn. My name is Rianne and I am the Program Manager here at Enterprise Nation. For those of you who are joining Enterprise Nation webinar for the first time, we are a vibrant community of small businesses and business advisors that exist to support and shortcut your route to trusted business support. If you have any questions during the webinar, please post them in the chat and we'll do our best to answer them throughout the session and mostly towards the end of the session. Today's webinar will be recorded and we will send a copy of the recording to you in the follow-up email with further resources. I want to welcome today's speaker, which is Laura West. Today she's going to cover all things intellectual property, what it is, why you should care, how to do your own intellectual property and to help yourself draw the line, and how to manage your intellectual property with a budget that is even limited at times. So thank you guys for joining today's session and I'm going to hand over to Laura.
Thank you very much. Hi everybody. Let me just quickly share my screen. There we go. So like Rianne said, we're going to focus really on protecting your brand identity here, but there is going to be broad coverage around what the different types of IP are and how they can help you protect your brand as well at the same time. I know intellectual property can be quite a dry subject, so bear with me. I've tried to make this as practical, useful and interactive as possible. And I really do welcome your questions as we go through. I get really bored of the sound of my own voice, so please chip in whenever you want. If you've got anything, if anything I say raises a question, just feel free to post it in the chat and Rianne can ask me. So who am I? I'm Laura West. I'm CEO of Springbird, which is a sort of challenger intellectual property legal firm that we started back in February. We sort of help all of our clients offering legal services in a different way via fixed fee packages and subscription model services in the legal world. We specialize only in intellectual property and in particular trademarks, copyrights and designs. So this is our sort of really niche area of expertise. Because we only launched in February, I know exactly what you're all going through as startups. I've literally just been through that process and still am, to be honest. I know how intense it is and how much you've got going on. But I really hope that this presentation helps you realize that intellectual property should at least be one of those many, many, many considerations that you've got in setting up your business. I am also a proud trademark owner, so I practice what I preach as well. So generally speaking, this is what we're aiming to cover within today's session. What is intellectual property? Why should you be interested and why should you care? And why should you look at potentially protecting that intellectual property? How much is it going to cost you? And when should you be considering these things when you're a startup? So the what? IP comes in only a handful really of different forms. We've sort of got 5 broad categories that it's split out into, and any single invention, brand identity, piece of software could potentially fall within multiple different categories all at the same time. So these are essentially the 5 broad categories of IP. Patents are really the technical area of intellectual property. So these are what cover really technical inventions. They cover the functionality of a particularly new and innovative product or process. Designs are more on the aesthetic side. So they're looking at protecting the appearance of your product or your app, your software, or even your brand identity. Trade secrets are confidential information. The biggest example that's always given is the Coca-Cola recipe. These are really things that sort of make your business tick, and they're what make you you. They are generally your USPs, and the way that you protect them is really to lock them down and keep them really strictly within the business so that nobody else external to that has any kind of access to those really crucial pieces of information. Trademarks are the main types of protection for brand identity. So this is where you're going to protect your brand name, your logos, and various other sub-brands and strap lines, for example. And then copyright is the final one. Copyright really is there to protect any kind of intellectual expression or artistic expression. So it covers a huge range of things, anything from software code and databases, which obviously aren't hugely artistic, but all the way through to film, video, sound, books, written works, and all that kind of stuff. And copyright is an automatic right in the UK, so it cannot be registered. To what extent should startups care about intellectual property? Like I say, I have been there very recently. I know that you've got all of these things going on, and they are so important to get your business up and running. But my plea to you today is to please add IP into that list, even if it's not something that you actively take steps to protect at this very point in time. Fit it into your plan so that you've at least considered it and you have decided whether or not it's important to you, whether or not it requires protection, and if so, at what point in the future you need to be looking at that just to make sure that you've protected yourself well. So it's not the be all and end all. It's not going to be everything. Obviously, I know all of these things are super important, but it should just be an essential consideration for any business, really. Considering that intellectual property really is what makes you different to everybody else in the market. It's your sort of special juice, as it were, that makes you you. And so you don't want to be just giving that away or diluting it by allowing others to just come and take it from you once you've spent so much time building it. So if we look at copyright first, as I say, these are the different types of works that can be protected by copyright. Anything from written works such as books, website text, marketing content, all the way through to artistic works, photographs, sculptures, paintings, films, and then the boring stuff like databases and code and those kind of things. From a branding perspective, the main one here really are logos, and it's worth you bearing in mind. We will discuss trademarks and how you can file to protect them in the UK and overseas. But it's always worth bearing in mind, particularly if you do have a limited budget, that copyright protection is automatic, and most of you are likely to achieve copyright protection as soon as your logos are created. So you're going to have a level of unregistered protection within those artistic works through copyright protection anyway. So if you're going to spend the money on filing a trademark, maybe you look at spending that budget on protecting the name itself or other elements of your brand identity, knowing that you've always got this sort of as a backup or a plan B. So what do you need to know about copyright, particularly from a branding perspective? So like I say, protection's automatic. So as soon as sort of pen's put to paper, you've got an automatic right. However, you always need to be able to establish that right in future, which means that record keeping is really key. So you need to be able to prove to anybody in the future that asks, particularly obviously if you need to bring legal proceedings or a court needs to see exactly when that work was created, who created it, and how those rights therefore vest in your business. So obviously, if it was one of your employees and you've got an employment contract that confirms that all of the rights that they create vest within your company, that's perfect. Just make sure then that you've got really strong records that show the dates that these things were created, and if there's various versions, when the versions were created and when they were edited and how, and who was responsible for designing them. From the other side, in terms of using other people's intellectual property, which a lot of startups will do without necessarily realizing they're doing it, particularly in this age of social media, I always advise people to sort of start from the position that if you're using somebody else's IP, whether that be music, film, memes, logos, anything like that, assume from the outset that you're probably going to be infringing somebody else's legal rights, and then work backwards from there to see whether actually there's an exclusion or a caveat or some kind of permission you've been granted that means actually you are able to use them. Social media makes it really easy for people to just, create these reels, advertise their products, and then just quickly choose a song to add to the background, for example. But actually, if you're a commercial business and your Instagram account is a commercial account, you're going to need permission to use any of that music. So there will be in all of the platforms part of the sort of sound library that is free to use and royalty free, and you don't necessarily need to worry, but most of the mainstream stuff you're not able to use. And so if you are just adding those onto your product reels, you're likely to get some kind of cease and desist in the future. So even though the platforms make it look like it's all permissible and all really easy, just bear in mind that if you are using anybody else's kind of IP in that way, always take caution and think, actually, am I allowed to do this? Where is the permission coming from? When it comes to copyright infringement, so if somebody's copying your works, or if you might be using or adapting somebody else's within your work, the test for infringement is that it needs to be substantially similar, and you need to be able to show what's called copying. So copying is generally being able to show some kind of link between the original work and the work that's then been created. So whether that be, there was an ex-employee, so you can prove that they had access to the original work and have then moved on into another business, or perhaps you can prove that somebody accessed and downloaded some marketing materials from your website and then something very similar was launched a few weeks later. You need to be able to show that kind of causal link right from the very outset in order to establish any kind of copyright claim. And the test of substantially similar, it's vague, it's reasonably subjective, and unfortunately that's the case with a lot of IP infringement tests. But generally speaking, it needs to be pretty close. So if we were talking about a book, for example, if you take the plot but rewrite it entirely in your own words, it's unlikely to be substantially similar. If you've taken 60 of the 90 pages and pretty much copied them verbatim, changed a few words here and there, and substituted a couple of pages in, that may well be enough to be substantially similar. And also, this is a really big one for startups, particularly because you probably won't be doing a lot of the sort of creation yourself. I know a lot of startups will engage sort of web developers to help them with their website, logo developers to help them with their logos. You need to assume, again, that anything that anybody is creating for you or your business is probably owned by them, unless you actively get some kind of assignment of those rights to you or your company. A lot of people aren't aware that the automatic position under the law is that somebody who's commissioned to create something actually owns the works unless there's been an active assignment to the business. So when you're negotiating those contracts in terms of websites, marketing content, logos, make sure you've got some kind of clause or term or even agreement just via email from the person that's creating them to say, yes, we agree that once payment's made, all of the rights in the IP will vest in you. Just protect yourself. And that will be something that comes up all the time throughout the business. So always just operate from the space that if they're not within your business and there's no employment contract, they may well own whatever you've asked them to create. So always try and get some kind of confirmation that actually the rights are being transferred to you. Has anyone got any questions on anything that I've said so far? No? Okay. So trademarks, the most obvious ones that everybody thinks about are words and logos, really. So brand names and logos, and those are the most common. Trademarks are really there to protect your brand identity. So anything that a customer is going to see and immediately think, oh, I know who created that, or I know who that is. So the Nike swoosh, you see that, you know it's Nike. You see Just Do It, again, you know it's them. Cadbury, you see a purple packaged chocolate bar and you're likely to think that it's a Cadbury product. So it's anything that really designates you to the customer. And this can actually be a lot broader than brand names and logos. So as I've said here, it could be anything from smells, sounds, so jingles, or, the beginning of the Fox movies, that sound, the lion roaring, everybody hears it and they know exactly who it is. Symbols, shapes, it can even be packaging. So the types of right you can get via trademarks are a lot broader than a lot of people are aware of, but obviously the most common for startups is really just getting your brand and your logo protected if at all possible. So in terms of trademarks, obviously there's a registration system in almost every country of the world, and that will give you the strongest possible rights in your brand. However, as soon as you start using a particular trademark and assuming that there's not earlier rights that are an issue for you from a legal perspective, as you trade under that brand, you will start to accrue unregistered rights as well, a little bit like copyright, but this is called goodwill. So there's a recognition in the UK that as you trade and grow your presence in your particular market, you are sort of growing a customer loyalty, and people are starting to recognize that brand, even if it's not registered, as a symbol of your particular company. So these generally take quite a while to accrue. So you can't really rely on having those unregistered rights from the very outset. But say you've been trading for a few years, you've had consistent sales to various customers across the UK. It may well be that at that point you would have an established claim of unregistered trademark rights, i.e. goodwill, that you would be able to enforce against somebody else if they then started using a very similar brand to you within your market. Because of this, though, just like with copyright, records are really important, and it is harder, obviously, to establish this kind of trade presence than it is to establish a trademark registration where you've got the certificate and you literally just present that legal right. So again, you need to have records that show your presence on the market over that period of time and consistent trade and sales. So you need to be keeping records of marketing activity, customer invoicing, sales, advertising spend, social media reach, all of these kind of things, so that if you had to, you could draw upon them to substantiate that claim to reputation. When you're filing a mark, choosing the owner is really important. There's questions generally around, should I file it in my own name or should I file it in the name of the business? And this is something that varies depending on the company and what its plans are in the future. But generally speaking, the main thing I say to people is, remember, if anything happens to that business, all of the assets that vest in that business are going to sort of be tied to the fate of the company. So if the company goes down, for example, the assets are going to go with it. Whereas if they're owned by an individual, they're somewhat protected from, what happens to the business and could be used in future or licensed to another company, for example. When you file a trademark, I don't know if any of you have tried to in the past, but you have to sort of designate which categories of goods and services you want, and then you have to describe the goods and services within your application. This can look really easy when you have just a tick list on the IPO website, but actually I'm going to show you in a minute just how difficult it can actually be, and that there's quite a lot of nuances to this that you really need to be aware of, and just really educate yourself before you file that initial trademark application. Because once you filed it, you can't then go and change it. So you can tweak certain words, etc., if the office objects to them, but you can't add in categories of goods and services. If you need to cover extra stuff because you realised you missed it out, you're going to have to refile all over again, which means incurring those costs all over again, and then having two rights alongside one another that you're going to have to renew in future. The infringement test here is confusingly similar. So the main question we're asking is, if a consumer sees those two logos next to each other on a shelf, are they going to be confused and think potentially they're coming from the same source? And again, like I said earlier, anybody that's creating any kind of trademark rights for you, assume that they own those rights unless there's a transfer to you. So where should you start, particularly if you've got a limited budget? My advice to all startups is generally start with searching. So a lot of people just jump straight into thinking they just want to protect their brand. They've created it, they've got the logo, they just want to file a trademark application to know that they own it. But actually there's a step before that, which is really just making sure you've conducted the right due diligence to ensure that you own the rights to that brand and that you're not actually going to be infringing anybody else's, which could be a significant legal risk for the business in future. So more important than protecting it, in my view, at the very beginning, is making sure that you're safe to use it, and that you're not going to find yourself in a position where somebody challenges your trademark application, or even worse, threatens to sue you for trademark infringement because you're using a brand that's too close to one they already own. So Engaging a company like mine is the best possible way to search because we have this specific software that looks at the various registers and has AI that tests for any kind of confusingly similar mark. But if you don't have the budget to use a company like mine, there are a lot of tools online that you can use to sort of equip yourself and just make sure you're doing as much as possible yourself in terms of searching without necessarily having to spend a huge amount of money. So this is the first tool that I would say you all need to have a look at, particularly if you're going to be trying to file an application yourself. It's called TM Class. If you put that into Google, you're going to find it really easily, really quickly. And this is what's going to help you build your list of goods and services. And just as an example of the nuances that I told you, so if we just talk about a really simple offering, such as clothing, if you go into TM Class and type in clothing in the top bar, because that's what you sell and that's what you know you need to include within your application, you'll see lots of different types of items come up. But actually in the left-hand column where there's the class number, there's actually more than one class that clothing could fall into, or different services related to clothing. There's 570 results actually. So it can sometimes be difficult to really press down into actually which one do I need to cover and which is important to me. So once you've looked generally, look more specifically. So for example, I want sports clothing in particular. It's going to tell you straight away that's class 25. But actually, if you're looking at protective clothing, so workman's clothing or something like that, you put that in there, you'll see actually that falls within class 9. And if you're looking at compression garments, for example, you'll pop that in and realize it falls within class 10. So like I say, it's not as easy as you necessarily think it is to create this list of goods and services. And I would advise you spending a good amount of time on this tool and really drilling into what it is you're offering. There's a really useful thing you can do. So you just put the class in the needs class at the top, and this will just give you a list down the left-hand side of all the various different items that are generally covered within that class. And then you can click into each one and there's hundreds of results. So if you wanted to be super anal about it, you could spend a lot of time going through these lists, just making sure you've covered off everything that's relevant in each class. But like I say, at least spend the time really drilling down into what you're going to be offering and think about how you're going to be offering it. Are you offering it on an e-commerce website? Are you offering it in retail stores? And put all of these things into this tool to try and find the most relevant terms to describe what it is that you're doing. Then you need to start looking, has anybody else got this brand registered? So the first place you'll probably want to start as a UK business is the UK IPO. Again, you put it into Google and it's the first thing that comes up. So if you go to the trademark section and click search for a trademark, you'll be able to search by the word that you're looking to protect. And you can specify whether you want to see similar marks or actually if you just want to see anything that's exactly the same. You can also limit it by the classes once you know which classes you need. So you can limit the search down to those of most importance to you. And then you just click search and it's going to bring up anything that it can find that it thinks is similar to that brand that's already on the register. And you can then scroll through these, have a look at what they're covering in terms of their goods and services, see whether you think it's similar to what you're planning to do. Look at the company that owns it. Are they dissolved? Are they still active? Are they using it? And really start to get an idea of actually somebody else might have a right that could be a problem for me here. If you're a business that's then looking to move overseas, you'll probably want to look at TM View. So this is an equivalent to the UK IPO search, but it covers loads of different registers worldwide. So you're going to get much broader results here that cover various different countries. And again, you can specify which, or you can keep it really broad and just look across the world. Again, however, there's nuances to this. So you could put your brand name in just like I have, Springbird, and it's going to bring up 4 results. But just by adding a space in between the 2 words, you'll see that actually that increases to a number of additional results. So again, you really have to play around with this tool to make sure you're covering all kind of variations of your brand, how other people might separate it out or maybe spell it differently. And this will help you really find not just the brands that are exactly the same, but those that could fall into that confusingly similar infringement test. Again, you can limit this by goods and services to try and really limit down the results that you're seeing. and you can limit it by territory. So here I'm just getting the ones in our core territories, obviously, that we've already registered, for example. And as you all see now, you can also just drag and drop your logo into this tool, and you can look for similar logos that are registered as well. So it's got this sort of image recognition technology. Again, it's not quite as sophisticated as a firm like ours would use, but it gives you a good idea, and you'll be able to see straight away, is someone else using a similar logo to me in a similar sector within one of the countries that I know are going to be important to the business. So these are really handy free tools that you can really spend a lot of time just drilling down into, do your own due diligence, try and find as much as you possibly can, see if you're free to use, and try and help yourself without necessarily breaking the bank. Search engines are also your friends. So search Google, because like I said, trademarks can be registered and unregistered. You also need to be checking, well, has anybody not registered a similar name, but actually they've been using it for 10 years in the UK market? You also need to be well aware of that, because that could be a legal risk too. So spend a lot of time on Google looking for similar marks in similar industries, just to help yourself again with the due diligence that you can do for free. As I said, design protection is something separate to trademarks. It's there to protect the aesthetics, but again, it can be used to protect logos, packaging, patterns, as well as product shapes and styles. It can also be used to protect interfaces for things like software and apps. So it's another tool you can use to protect those different elements of your branding. Designs are really great because you get protection without having to categorize your activity into goods and services. You just get protection, broad brush protection, basically, for that particular design, regardless of what industry it's used in or which products or services. However, the tests for infringement and crossing it over are much more stringent with designs, so sometimes they can be harder to enforce, and things need to be closer than they would from a trademark infringement perspective for there to be any kind of copying. They are also time critical. So the main thing to get across to you is, if you do want design protection, whether it be for your logos or look and feel of your product, within the UK, you've only got 12 months from when that design first goes public to file for that protection. And after that, if you file it, anything's going to be invalid. Again, there's a provision for unregistered rights in these things in the UK, but it's reasonably limited, particularly for 2D and graphic works. It will only last you 3 years. So just bear in mind, again, like I say, make this an essential consideration at the beginning, because there is a time limit on when you can file for some of these rights. And you want to make sure that you've got as much as possible in terms of your arsenal and protection. So like I say, diarise that grace period, make sure you're keeping track of it so that you don't go over those 12 months if protection is something that you want, because that grace period starts running as soon as something goes live or goes public. Use NDAs wherever you can to keep it under wraps and keep it confidential for as long as you possibly can. Design protection is really cheap, as I'll show you in a minute. So if you're in doubt, and it's quite easy to file yourself on the IPO register. So if you're in doubt, I would say file what you can. Of course, in an ideal world, you speak to an attorney and make sure you're not going to undermine any potential future rights that you've got. But for some businesses, it's better to have something than nothing. So have a look into it and see if that's something you want to do, but bear in mind the time considerations. Why should you be doing this? I think I covered this at the beginning, really, but this should be something just like insurance, VAT registration. It's something that you should be doing to protect your business and really protect what it is that you're building and your identity, so that other people can't copy you. It gives you another asset, just as your physical assets, so your office, your computers, that kind of stuff, but it's an asset that can really increase in value over time, and it can be used for security against other assets in the future, for finance, for loans. And obviously some of the biggest brands in the world have an enormous value attached to them, so that's why it's really important. You can also extract revenue from sort of licensing activity and franchising and models such as that. So it can really deliver revenue to the business, perhaps in, product areas that you're not interested in, but other people really want to make use of your branding. And obviously it helps you fight off those magpies that just want to ride on your coattails and just copy what you've done after you've already spent the time and effort creating it. Ultimately, identifying and protecting your assets is never going to be a bad thing, in my opinion. And it doesn't need to break the bank. So if you are one of those businesses with a really technical offering, an invention or a really innovative process, patents are the most expensive types of IP, right? And generally you are going to be looking upwards of £5,000 to get a UK patent drafted properly by an attorney. Copyright is automatic, so it's free here. You can register it overseas, but here you can't. So it's a free right. Always make use of it and make sure you've got those records. Design protection starts from £50 in the UK. So again, if you're going through this process yourself and making sure you're doing the right kind of due diligence, it can be a really cost-effective way to protect yourself. And again, trademarks, if you file yourself, the starting fee is £170. So it doesn't need to break the bank to at least get you some level of protection, as long as, like I said earlier, you've done that sort of due diligence beforehand. Where do you start? Great start being here already. Start by identifying the IP in your business. Make a table, make a spreadsheet so that you've really started to think about what are the different types of IP that we actually have, what makes us special, what are our assets, and which types of IP right do they fall into, and do we need to be doing something about it? So make a plan and include it within any kind of form, forecasts or investment proposals, etc., so that you get that budget in place. You'll obviously get these slides afterwards, but this is an example of the kind of report you can look to create. So you've got your various assets down the left-hand side. You've looked at who created it. You've perhaps rated it in terms of how important it is to the business and how integral it is to the commercial operation of the company. And then you can decide, are we going to keep this secret or are we going to protect it by putting it on the public register? How long have we got? What's the risk if we don't actually do anything about this? Are we going to lose the right to protect this in future, meaning people could just copy us, or actually there's going to be an increase in cost, but other than that, no real great risk. And you can then start to make a really informed decision about what you do with your assets. So I really hope that was useful. There's my details if you do want to get in touch with any questions or if you want to discuss any of this in more detail. But of course, if you've got any questions now, please feel free. I'm happy to answer them.
Thank you so much, Laura. That was such a useful session. It was really, really, really interesting. If I could just ask everyone to start putting any questions that you might have for Laura into the Q&A chat for us, that would be fantastic. And I just want to apologize because I know a few of you had a few issues joining today. That's completely a technical issue. I'm not really sure what happened, but the recording will be sent out following the session in the follow-up email. But yeah, just to kind of get into some of those questions. So we have one here. They said, can you trademark a framework presentation or workshop in the UK? So something that's kind of like a form of like actual information or education. Can you trademark that?
So like I said at the beginning, trademarks are really there to protect anything that identifies your company as you. So when it comes to presentations and frameworks, generally that won't be the case unless you created sort of specific diagrams that play into that framework, for example, that then become known as that particular company's diagram that could potentially be trademarked. But generally speaking, presentations and workshops, obviously all the content that you create in delivering those workshops will be automatically copyright protected as you create it. It might be that if there's a specific look or style that you use in delivering those workshops or giving those presentations, that can be protected by a design registration. But from a trademark perspective, you're probably going to struggle unless you're using specific identifiers that people are going to see as part of those presentations or workshops and be able to say, oh, I know what that means. That means this is coming from this company, for example. That's really what a trademark's purpose is. So you'll have to look at the other types of IP, right? And also use of really strong contractual arrangements like NDAs when it comes to frameworks and presentations and workshops, to make sure that even if you can't actively protect them by a registration, actually the people that you're showing them to and that are engaging in those workshops don't have the right to then go away and copy them or use them because they're contractually bound by some kind of confidentiality or non-compete, for example.
Perfect. That's really useful. We'll have one more question because we have slightly run over. We'll have one more question. That's absolutely fine. Great. You know, the information is honestly invaluable. And it's from Melanie, and she has asked, she's also a solo entrepreneur, and she's asked, is it worth protecting your brand if you don't have many clients and it's quite an early stage of your business?
If you have the budget, yes, always earlier is better, because the more time it's out there and the more clients you then build, the more likely it is that somebody is going to have protected something in the meantime that could then potentially be used to stop you from your ongoing trading. So until you're at a place where you've got, like I say, that sort of 3 to 5 years of ongoing trade, you're not going to have any rights in that brand, which means somebody else could potentially file something very close and then arguably use that against you or prevent you from filing it in future. So if the budget's there, I would always say as early as possible from a protection point of view. And just one thing, sorry, I know we are running over, but that I wanted to mention is that there's a 6-month priority period with most of these intellectual property rights. So once you file that first one in the UK, you're generally given a 6-month grace period then to be able to file overseas, but backdate those overseas filings to the date of your UK one. So even if you just file it in the UK because it's one of the cheapest and quickest systems, you've almost bought yourself a 6-month grace period then for then considering overseas protection. So it's a really good sort of marker in the sand for you to have.
Perfect. That's really, really useful. And I think that will be very relevant to the audience today, because a lot of the businesses that we have here today are startups, are new businesses. So that's really amazing. Thank you so much, Laura. Today's session has been absolutely amazing. And just before we quickly sign off, I just wanted to say to everyone, we are giving away 5 £50 not on the high street vouchers to those of you who are willing and wanting to be Startup UK case studies. So if you have benefited from today's session with Laura or any of our other Startup UK sessions, please feel free to click the link in this chat, fill out the form, put as much detail as you can do to be in the running for a £50 voucher for Not on the High Street, as these case studies really, really make a difference to our programs and all the events that we run. So please, 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 if you do get a chance, fill out the case studies. But once again, I just wanted to say thank you so much, Laura, for today's session. It has been absolutely amazing and we have all benefited so, so much. So thank you all, and I will see you in the next webinar. Thank you.
Thank you, everyone.